Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today I like to talk about one labor case related to the employee status. So the title is telemarket unemployed. So sometimes we are confused. The telemarket they are selling some product or insurance to the customers. So when they have some sales or they have a good sales result, then they got paid more. So their salary is decided by their performance rather than their working hours or overtime. So usually telemarket is regarded as a freelance or the contractor. So they are not applicable to protection of labor standards. That is a normal case. But when employer gradually control the telemarket more and more, then their status gradually become employee rather than contractor, because they are strictly controlled by the employer for working hours, workplace, or work ethic, even their work performance. Then gradually their status become the employee from the contractor. So that is the case. So here what I'm trying to say in this case is telemarket who was terminated because of low performance. So company thought this telemarket is a freelance or the self-owned contract. So it is possible to terminate just giving 1 month's notice. So they thought so, and they terminate the contract. But the telemarket thought they are employees, so they take remedy application to the Labor Commission. So Labor Commission reviewed the case, and they judged this telemarket especially can be unemployed because they are controlled very exclusively or strictly. Also, they even they earn the money based on their performance, but performance also is controlled by the employer very strictly. So their status is not freelance anymore. So judges in the Labor Commission judged this telemarket is employee. So this termination is illegal because the company didn't follow basic requirement for termination, like issuing written notice for termination. So in this labor case, how we understand employee status. So Article 2 of the Labor Standard Act stipulated employee means someone who provide labor service in return for labor, in return for wage in the workplace. So this one sentence means employee work for particular employer. Also, they receive the wage in return for providing the labor service. Also, a third one is they continually to provide labor service exclusively in particular workplace. So these conditions justify who is the employer, and I'm the freelancer and employee. So also Supreme Court ruled regarding the employee status. So they don't consider the types of contract, whether it is commissioned contract or service contract or some other types of contract. But actually they work as employee, then it is important. So in this working relation, also they judged based on subordinate relation in the workplace, like they control workplace or working hours. Also, whether they are workers and that they are applicable to the company the work rules. Also, their salary, whether they earn the commission based on their performance, or they receive the base pay plus incentive. So based on those items, Supreme Court ruled so they are more close to the employee side than the status is the employee, but they are more they have more free from employee subordinate relation. Then also wage is more commission rather than the wage or the reward for their fixed service. So in that case, the Supreme Court ruled they are more like freelance or contractor rather than employee. Okay, this is all I want to explain more in other labor cases regarding employee status. Thank you for watching. Bye bye.